The first major constitutional change that we are going to discuss in this class is the 14th Amendment. Actually, the three Civil War amendments, the 13th, the 14th, and the 15th, the 13th getting rid of slavery, and the 15th at least nominally assuring voting rights for African Americans, together are considered to be the Civil War amendments, constituted a major change in American constitutional history, but the constitutional amendment that had the most lasting impact and that came up again and again in Supreme Court decisions and led to a wide range of constitutional changes, that's the 14th Amendment. If you read the Ebb article, which I have you read today, you'll see that Ebb spent several pages explaining in which way the 14th Amendment actually changed the constitutional interpretation of the Supreme Court and expanded civil rights and civil liberties, for example. So, what I'd like to do right now is to give you an overview of the text of the 14th Amendment and what the different parts of the 14th Amendment mean, or at least what they are. What they mean is really a long-term project that the Supreme Court is still not done interpreting. So in the next step then is to take a look at the background that led to the 14th Amendment. And that background is partly Reconstruction, and that's why I have you watch a documentary on Reconstruction, but also what happened before the Civil War. The so-called slave power idea is, according to Garrett Ebb, really important, and I think it's really useful to understand it because at least I found that it really helps us understand what the 14th Amendment is about and what the framers might have had in mind when they wrote the 14th Amendment. We can also then use this discussion to see if we can make a connection, for example, between Dworkin's argument about fundamental values in the Constitution and the slave power argument, and try to identify what fundamental values are coming through the slave power argument. Okay, let's start by looking at the 14th Amendment. The 14th Amendment was passed by Congress in June 1866 and ratified by July 9, 1868. That was the date when the last state that was needed for ratification, that was Georgia, actually ratified the amendment. The 14th Amendment has 5 sections. The first section is probably the most famous one. You see here that the first sentence is the famous clause that makes sure or establishes citizenship of all people that were born in the United States or who are naturalized. So this means that, for example, former slaves were citizens as they were born in the United States, for example. The next phrase is the so-called Privileges or Immunities Clause of the 14th Amendment. It played an important role in the slaughterhouse cases, which we look at this week. The next clause is the Due Process Clause of the 14th Amendment. It says that states have to respect life, liberty, or property and cannot deprive any person of those without due process of the law. The Due Process Clause has come to play an important role in the question whether the states have to respect the Bill of Rights. It may be surprising to many of you, but the Bill of Rights, the first 10 amendments of the Constitution, originally only applied to the federal government. So only the federal government, according to the Bill of Rights, had to respect freedom of speech, freedom of the press. Only the federal police had to get search warrants to search homes, etc., etc. Now, the Due Process Clause was used by the Supreme Court throughout the 1900s to basically apply most of the Bill of Rights to the states, so that, for example, the state police had to respect Fourth Amendment provisions for search warrants and so on. And the final clause of Section 1 is the so-called Equal Protection Clause, which plays such an important role in many civil rights cases. It's really about equal treatment of different groups in society that are not supposed to be discriminated against. Section 2 deals with the abolition of the 3/5 clause. You may remember that under the original version of the Constitution, there was this oddity that slaves were counted as 3/5 of a person. Now, slaves didn't have the right to vote. Only white men, originally white men with property, real estate, land, were allowed to vote. But still, in order to apportion how many representatives each state had and how many members of the electoral college each state had, how many electors states had, slaves counted as 3/5. So that meant that even though only white men voted in the slave states got additional representation in Congress and in the electoral college and thus gained more power in the federal government. Now, what happened with the abolition of slavery in the 13th Amendment? What happened was that suddenly there weren't slaves anymore. Now, the white elites in the South wouldn't give former slaves voting rights necessarily, and nevertheless, they now had the full count of former slaves to reapportion their representation in the House of Representatives and the Electoral College. So instead of having just a 3/5 representation for every slave, they now got a full representation for every former slave, but didn't let former slaves vote. Okay, so this section of the 14th Amendment tries to deal with this by saying, okay, if not all men in the South get the right to vote, then those, or if not all men get the right to vote in any state, that state gets reduced representation in the House and in the Electoral College that's proportionate to the number of people in those states that are not allowed to vote. I hope this makes sense. It's a little bit complicated, but I think if you read the ABS article, you'll see that it features in the slave power system and the complications that came along with abolishing slavery and not giving the former slaveholders additional power in that process. Section 3 basically says that Congress can pardon former officials of the Confederacy who want to participate actively in national politics again. So those who want to get elected to Congress and so on. Now, that's in reaction to presidential reconstruction, under which, well, under the pardoning power of the Constitution, it was President Johnson who pardoned former members of, or former officials of the Confederacy, and it turned out that Johnson was really lenient and kept pardoning people without many preconditions. And now instead Congress says, okay, we are the ones who issue the pardon so that we can make sure that not everybody just gets a pardon for nothing. In Section 4, the 14th Amendment basically says that Congress will continue to pay the debts of the United States, but it will not pay for the debts incurred by the Confederacy. Finally, Section 5 gives Congress the power to pass laws to enforce the 14th Amendment. And that's again really important and still relevant because it gives Congress an additional power to pass laws and make policy. Originally, Article 1, Section 8 of the Constitution contains most of congressional powers. And for example, one of the powers is the power to regulate interstate commerce. That's something we'll discuss in a few weeks with more detail. Now, if you think about interstate commerce, there are things that are not included in interstate commerce, things that happen just in the states. Now, Section 5 of the 14th Amendment basically gives Congress the power to regulate those things in the states if they're connected to the 14th Amendment. So, for example, if they're related to discrimination. All right? So, this is really an important part that Congress can still use to gain powers or to justify its powers. I think that you see that all sections of the 14th Amendment were really important in the historical situation, but some are really still important today because they're used by Congress to justify laws that they make, but also by the Supreme Court um, to protect minorities, for example, and make new rules. So what we'll focus on in the next couple of weeks are particularly Section 1, and the clause that will play a huge role in the end is the Due Process Clause. But first we'll focus on the Privileges or Immunities Clause, which was at stake in the slaughterhouse cases, which also dealt with the question of whether the 14th Amendment was actually a proper constitutional amendment. All right, I hope I went